If you filed a petition and it is yet to be empaneled, it is upon you as counsel to follow it up with the deputy registrar of the court. First of all, we have to ascertain whether you applied for empanelment, because it's not automatic. If an order for empanelment was made, follow it up. That is the only time you can know what happened. When the file is empaneled, comes before us, we will deal with it. For the matters which were empaneled, and maybe they are not here, we presume they are not before us because we were not moved. We have handled the matters today because we were moved by an application. If you feel we need to look into that matter expeditiously, you may have to consider. But at the appropriate time, we will issue comprehensive direction on all the matters which were paneled with, which we were paneled, even if there will be no applications. So let us get it clear so that as we move forward, we avoid this back and forth of getting us back to matters which were either paneled or not paneled. Let's be focused. We will deal with every matter, but now we are dealing with matters where we have been formally moved. Thank you.
Yes. Thank you. Very well guided, and we do thank you for holding the platform.
My Lordship and my lady, on behalf of the respondents, I want to thank you for according us this afternoon to this evening. I want to thank
With respect to the most recent fact, he has shown that the court must be respected by herself personally appearing in court. There are some previous Attorney General whose name I would not like to mention, but who are full-time officers work.
So we reconvene tomorrow, the 23rd of October at 3:30 p.m. Thank
you. In such an epochal moment, that what you do here has significant ramifications for the Republic of Kenya. It is for you as a court to rise to the occasion. This court has defined the Constitution as a transformative constitution. And this was done by this very court, differently seated in the BBI case, David, Lee, and others, versus the Attorney General. And this is what the court said about the Constitution 2010. It is a constitution of a transformative character, and this transformative character of the Constitution induces large-scale social change, including the character and conduct of politics. That the Constitution bears an internal theory of interpretation. Starting point for discerning that internal theory is Article 259 of the Constitution. That formalistic approaches to constitutional interpretation are not favored. And lastly, that the Constitution has provided for its own theory to protect its values, objects, and purposes. That is what is before you as a court today, that you are supposed to maintain that innate character of this Constitution as a transformative charter. The other side has filed grounds of opposition, and in their grounds of opposition they raise a case, Lona Conchela and others versus the Chief Justice. That was the grounds of opposition by the Attorney General. And in that case, this High Court said that the power to appoint a bench is administrative, and that power can be performed by the Deputy Chief Justice in limited, constricted circumstances. So that the normative holder, the Chief Justice, performs it, but the Deputy Chief Justice has to perform it in certain limited circumstances. Those limited circumstances have to be demonstrated. That is concealed. Your Lordship Justice Milimani, sitting in Okoiti versus JSC and another petition, E408-2020, 2021 EKLR, I believe that is what Professor Gini Miguel was asking about. Paragraph 29, 38. Justice Milimani finds that the authority under Article 165(4) is a constitutional authority, so that that authority cannot be delegated by the Chief Justice, because the Chief Justice does not cease to be a state officer, even on leave. We have another authority here, Petition 31 of 2013, Kenya Medical Research Institute versus the Attorney General. This is found at 2014 EKLR, at paragraph 37. Kenya Medical Research Institute versus the Attorney General and three others, 2014 EKLR. This case at paragraph 37 says this, that the Chief Justice under Article 165(4), the authority to empanel a bench, performs a constitutional mandate. And this is not an administrative function, as was in the old constitution. Where do we go? I'll invite the court to look at the express wordings of Article 259(3)(a) that expressly decrees that authority granted to a specific office must be performed by that specific officer. That is Article 259(3)(a). I'll want this court to consider the decision of the Court of Appeal, and this, the other side can take judicial notice of, the court can take judicial notice of the case of Karisa Chengo, whereby the office of judge and the person of judge are synonymous. So that the Chief Justice, the person, and the office of Chief Justice are synonymous. And therefore, we cannot separate and delink the holder and the person. And therefore, if the Chief Justice were to delegate any responsibility to the Deputy Chief Justice, assuming that was possible, then the Deputy Chief Justice has to take an oath by virtue of Article 74 in the Constitution. There has to be instruments prepared authorizing the DCJ to act as Chief Justice, and for what purposes? Ladies and gentlemen, the Honorable Court, the Greek tale of Ulysses, the coxswain who was asked to block his ears using wax and to avoid the temptation of alluring music, that story echoes well for you today. It's politics, there's a lot of heat and rancor, but for you, as the court, an apex court by the Constitution, yours is to uphold and defend this Constitution as required, as Article 3. That's the sole mandate of this court. Thank you.
The Leila Conchela case at the High Court level presents it as an administrative function, but we now know that the Court of Appeal has found that to be an arguable point on appeal and has given a stay order on the strength of that arguability. The weight of that jurisprudence militates against finding that this is an administrative decision, as has been urged by my colleagues on the other side. Since I have only 5 minutes, an issue arose here, my lord, my lady. We tried to object, but we were told we will have a right of reply. Professor Jenda presented a piece of paper from his hands, claiming it's a memo from the Chief Justice. We sought clarification on where that paper has come from. First, his argument was it's in the portal. We sought to know in which case file in the portal that paper has come from and why it has no time stamp that is symptomatic of all documents that are lodged in the portal, and there was no clarity on that. He then said Mr. Nyamodi will comment on it. Mr. Nyamodi stood, began, and concluded his submissions without commenting on it. He also told us it is in the file. Papers like this will find themselves in the file through affidavits. This evidentiary material. Again, we were not told which affidavit or which deponent filed on which day. We will therefore urge you that as you consider this matter, you take into account that we have not had a fair opportunity to treat this piece of evidence in its proper context because of the, with respect, woolly nature of the manner in which it has been presented before this court. I urge, my lords, that in view of the matters raised before you, this matter ought to finally clear the position of this court on the jurisprudence of Article 165, Clause 4 of the Constitution, to give it considered thought, and that you return this file back to the appropriate authority, the Chief Justice, to do that which is just and right, as per Article 165, Clause 4. In matters as fundamental as this, in a matter where we all agree that this is a defining moment for our country, we cannot afford to be casual about it. We cannot afford to be expedient about it. It's in matter that is where a question of principle arises, and of all the three organs of government, only one organ stands out for standing on principle, the judicial arm of government. All other arms of government stand on politics and policy, but principle is reserved for the judicial arm of government. We urge you to admit that principle and find that the applicants and their supporters before you have made out a case for you to down your tools in this matter on the strength of the manner in which you are constituted. I rest.